The Lord does not envisage that one portion of land can have two title deeds. But it's a very, very common practice in this country. How do you know which one is a genuine title deed? Welcome to Court Helicopter Explainer. We wish to thank you for being our subscriber. We started from 0 subscribers. We are now 70 plus. We wish you a good thank you for having supported us up to this level. Today we are talking of a topic that is very, very critical in ownership of property. Land having two title deeds. Do you have a title deed and somebody else has a title deed over the same land? Have you been sold land and you have a title deed? You have gone to the US, you come back, you find the land that you bought, a building has been built. You rush to court, person brings out a title deed. There are two title deeds. The Lord does not envisage that one portion of land can have two title deeds. But it's a very, very common practice in this country. How do you know which one is a genuine title deed? Yours, you got it from the land's office. The land registrar gave you the title deed. The other person is saying, I also got one from the same land's office. The land office is a government bureaucracy. It is supposed to have a one land title deed or certificate of lease for each parcel of land. The title deed number is like a national identification card number. You cannot have two national ID numbers. You have one. You cannot have two index numbers for doing your examination. You cannot have two passport numbers owned by two different people. But today, our crew Vivian dug into the libraries and the case laws and found out this matter. It is very, very educating. This is a matter in the Environment and Land Court at Makueni. This is the land case number 226 of 2017 between Patrick Ndiwachalo and Mutua Katumu Nduti. Justice Murigi J had to make a decision between two title deeds. What happened? Paragraph 27. It is the plaintiff's case that he holds a valid title deed to the suit property, having acquired the same through the land adjudication process. In this regard, the plaintiff produced a letter of offer from the settlement fund trustees dated 5th October 2011. 2. He produced payment receipts. 3. He produced a letter of acceptance dated 14th June 2012. 4th, he produced stamp duty forms and the payment receipts that show that the consideration for the suit property was 21,789. He produced the receipt. And he paid in addition to other connected expenses related to transfer of the suit property. The land registrar was called to court. He is PW2. The land registrar produced 2 green cards registered in the name of the plaintiff and the defendant. Imagine, the land registrar has 2 green cards. One registered in the name of the plaintiff and the other the defendant. The green card registered in the plaintiff's name outlined 5 entries that have been made in respect of the suit property. For the plaintiff, there are 5 entries. Entry number 1 indicates that the suit property was originally registered in the name of the settlement fund trustees. The second entry corroborates the plaintiff's evidence that the suit property was indeed transferred to him after complying with the mandatory requirements laid down by the settlement fund trustees. The defendant took the dog. The registrar of land seems to be supporting the plaintiff. The defendant took the dog and said the defendant did not produce any documentary evidence in support of this claim to the suit property, other than the title deed that was issued to him. It is not in dispute that the suit property. So, the question, the first person produced documents plus a title deed. The second title deed, the man has only a title deed. He did not have anything to that effect. The judge went further and said, although the defendant has a green card registered in his name, there is no entry to indicate that the settlement fund trustee was the first proprietor of the suit property. He did not produce any evidence to show that he was issued with a letter of offer and acceptance in respect of the suit property. Similarly, the defendant has not adduced any evidence to show that he paid consideration or he paid to the original owner. Even during cross-examination, when he was questioned as to the circumstances he took occupation of the suit property, the defendant testified that he was orally given permission to do so by the government surveyor. What is the law when there are 2 title deeds? This, in paragraph 39, listen very carefully. This was a case of Hubert L. Martin and others versus Margaret in 2016. The judge in that case said, of course, the issuance of 2 title deeds is not contemplated in the law and, strictly speaking, should never happen. A court, when faced with a case of 2 or more title deeds over the same land, has to make an investigation so that it can be discovered which of the 2 title deeds should be upheld. This investigation must start at the root of the title and follow all processes and procedures that brought forth the 2 titles at hand. It follows that the title that is to be upheld is that which conformed to procedure and can properly trace its root without a break in the chain. The parties to such litigation must always bear in mind that their title is under scrutiny and they need to demonstrate how they got their title, starting with its root. No party should take it for granted that simply because they have a title deed or a certificate of lease, then they have a right over the property. The other party also has a similar document, and there is therefore no advantage in hanging one's case solely on the title document that they hold. Every party must show that their title has a good foundation and passed properly to the current title holder. Paragraph 40. The plaintiff demonstrated the root of his title. The certificate of title produced by the plaintiff shows that it emanated from the government fund. The defendant, on the hand, did not demonstrate the root of his, as he failed to substantiate his claim to the suit property. His title does show where the suit property originated from. Paragraph 44, the last, having established that the plaintiff is the registered owner of the suit property, I find that he is entitled to all the rights of interest and privileges belonging to him. It is not in dispute that the suit property is registered in the name of the plaintiff and the defendant. A parcel of land cannot have two titles. The plaintiff demonstrated the root of his title. The defendant, therefore, does not hold an absolute and indefeasible title. In the end, I enter judgment to the plaintiff against the defendant in the following manners. A declaration is hereby made that the plaintiff is the bona fide owner of that title of land. An order is hereby issued cancelling the defendant's title for that land. Lastly, an order of permanent injunction is hereby issued restraining the defendant, his agents, servants, or employees from leasing, transferring, cultivating, or in any other way whatsoever from interfering with that land. An order of vacant possession is hereby issued in favor of the plaintiff against the defendant. Judgment dated and signed via Microsoft Teams on 12th day of March 2025. Justice Teresia Brie. What is the import in this very dangerous authority? One, that there is a possibility that two title deeds exist. There's another title deed over your land. Two, if that title deed exists, it must have originated from the lands office. Many Kenyans are mad when they hear that the same lands office can give two title deeds. It happens. Many Kenyans are mad that two green cards can exist in one land registry. It exists. So the question the court is saying, you must show how the root of that land came to you. We told you the first thing that you do, you must get a root search. Here you see how the land came to the person selling to you that land. Two, a sale agreement must be there. Three, you must go to the surveys to get a map. Four, you must go to the land control board to get the consents to subdivide. Five, a mutation must be drawn showing that this land has been subdivided. Six, evaluation must be done for you to pay stamp duty. You must pay stamp duty. Pay your stamp duty. Don't allow an agent, a broker, to pay your stamp duty. Or let your advocate pay stamp duty and you get that receipt. Six, then you are issued those transfer forms to be accepted by the registry. Then you are issued a title deed. Many of the people have title deeds. Brokers have told you, you pay, I'll go and bring you the title deed. You have a title deed in your house. You have a title deed in yourself. The root of that title is what the judge looks at. Have you checked the root of your title? If you have not, like my friend here, this friend of mine called Mutua Katumu Nduti, his title deed was revoked and cancelled. Make sure your title deed is not revoked. Follow due process and keep all entries. Remember, every entry on a land transaction must be registered in the green card. If it is not entered, the land registrar will come and say, yes, There's a title deed here with a green card, but there are no entries. Now you have learned. For your title deed not to be revoked, that is the procedure. Can the High Court or can the Environment and Land Court revoke a title? Yes. So stop walking and chest thumping that you have a title deed. If you have not all the entries in the green card, that is a paper. Akili, Dan Senomari, always warning you, especially the people from the diaspora. You bought land 1970. Are you sure there is no any other title deed that has been issued? Keep watching. We are happy that we are 70 plus in subscribers, courtesy of your contributions, watching and listening to us. We appreciate. Thank you very much.